Assalamualaikum and hi everyone. My name is Izzati Shazwani binti Baharudin.
Assalamualaikum and hi everyone. My name is Nurul Syairah binti Kamaruddin.
Hi everyone, my name is Kuratu Aini Arina binti Azman.
Hi, my name is Nar Ani Syairah binti Aziz.
Assalamualaikum warahmatullahi wabarakatuh. Today, our group will present the current issues in auditing, which is Whistleblower Protection Act 2010.
I will start my part, which is introduction. There has been a significant rise in the awareness of the importance of blowing the whistle as a method of ensuring transparency, accountability, and avoiding potential harmful. A whistleblower can be used as a means of improving the internal organization culture. Moreover, the whistleblower has been hailed as heroes for bringing to light instances of fraud within organization and helping to prevent potential mistakes. Whistleblowers are more likely to be those who have a more positive response to their jobs and have been employed by the organization for a period of time. Then, they have a general perception that the company will be responsive to the employee complaint.
Assalamualaikum. My name is Izzati Shazwani binti Baharudin. So next I will discuss about the whistleblower. Whistleblowing is described as when an employee believes his or her employer has committed a wrongful or detrimental conduct to the general public and reveals the alleged act to the media, government or any organization's top management official, according to Lawrence and Weber 2014. The terms of whistleblowers refer to the informant who reveals that someone has engaged in or is engaging in acts that are prohibited by laws or regulations. According to Malaysian Anti-Corruption Commission (MACC), the Whistleblower Protection Act 2010 Act 711 is a law that encourages the revelation of information regarding corruption and other forms of wrongdoing. The purpose of the Whistleblower Protection Act was an act to safeguard persons from being exposed and retaliated against for reporting misconduct. Thus, this legislation can help to avoid corruption and abuse of power. There are 7 major or lead enforcement agencies have been conferred the rights, functions, and powers to undertake the investigation and enforcement processes for the Whistleblowing Act. They are namely the Malaysian Anti-Corruption Commission's (MACC), Royal Customs Department, Immigration Department, Road Transport Act, Companies Commission of Malaysia (SSM), Security Commission (SC), and the Royal Malaysian Police. The type of protection for whistleblower according to Whistleblower Protection Act 2010, Section 7, Clause 1, Clause A state that the identity of the informant and the information provided is kept confidential and not to be disclosed to anybody, even during the trial in court. Section 7, Clause 1, Clause B state that whistleblowers should not be liable to any civil action, criminal or disciplinary consequences of such disclosure. According to Section 7, Clause 1, Clause C, whistleblowers are protected from any act prejudicial to the outcomes of the reaction disclosures have been made. And lastly, Section 7, Clause 3 state that the protection is also given to those who have connections or relationship with the informant.
Hi, my name is Kuratu Aini Arina binti Azman. For my part, I will tell you the real-life case study for our topic whistleblower, which is the case between Dr. Syed Omar Syed Agil and Institute Professional Baitumar, IPB. Institute Professional Baitumar IPB was established by the Federal Territory Islamic Religious Council and the Federal Territory Foundation on April 23, 1992, with the intention of producing professional Muslims who are then be able to assist in enhancing the economic status of all Muslims in the country. In April 1992, they commenced their operations at Wisma Awal, Jalan Raja Muda Abdul Aziz, Kuala Lumpur, and then in June 1996, they moved to their current location at Lot 1363, Jalan Perkasa of Jalan Kampung Pandan, Kuala Lumpur. Up until now, Institute Professional Baitumal (IPB) is known as a private tertiary institution in which 70% is owned by the Federal Territories Islamic Religious Council. So, what is happened between Dr. Syed Omar and Institute Professional Baitumal? Dr. Syed Omar Syed Agil, a former Chief Executive Officer, CEO of Institute Professional Baitul Mas Tindian Berhad (IPB), allegedly exposed the financial misdeeds of his co-workers, had sought protection as a whistleblower in order to avoid retaliation for his actions. While working with IPB, Dr. Syed Omar became aware of some questionable financial practice by its staff, which he thought to be disciplinary and criminal offences. So, he lodged a report of possible instance of corruption and financial mismanagement committed by the officers and staff members of IPB to both the Malaysian Anti-Corruption Commission (MACC) and the Royal Malaysian Police (PDRM). An investigation into the disclosure of improper conduct under the Penal Code was then announced by the police. The first issue that we can upraise from the case is, in accordance with the Whistleblower Protection Act of 2010, did Dr. Syed Omar Syed Agil qualifies as a whistleblower? Dr. Syed Omar, even though in his position as the CEO of the Institute Professional Baitul Mal Sdn Bhd (IPB), is very courageous and has the audacity to submit various disclosures of improper behaviour by the staffs of the IPB to the MACC and PDRM. After taking into consideration of the surrounding, supporting facts and circumstances, the court has reached into conclusion that Dr. Syed Omar has met with the requirements to be considered as a whistleblower under Act 711 Whistleblower Protection Act 2010. Next, the second issue is whether the Institute Professional Baitul Mas Sdn Bhd (IPB) has taken detrimental actions against Dr. Syed Omar. As a result of the disclosure, IPB took various disciplinary actions against Dr. Syed Omar, asserted that it is a form of retaliation. IPB had dismissed him from his post as the CEO of IPB on October 7, 2015, and on October 19 the same year, they had taken disciplinary actions against him. However, the cross-examination findings from the court's investigation revealed that Dr. Syed Omar's allegations of misconduct made by IPB were more of a follow-up talk designed as a desperate defense when nothing existed to prevent Dr. Syed Omar's allegations that detrimental actions was taken against him because of the report done. As a result, from this case, Dr. Syed Omar has won his lawsuit against IPB. The High Court judge has issued a ruling that Dr. Syed Omar was successful in his bid to strike out the notice of internal investigations against him for the disclosure of improper conduct to the authorities. The judge also came to the conclusion that IPB was unable to demonstrate that the action taken against Dr. Syed Omar was not a form of retaliation for the fact that he disclosed the suspected improper behaviour to the police and the Malaysian Anti-Corruption Commission (MACC). The judge also has ordered Institute Professional Baitul Mas Sdn Bhd (IPB) to pay RM18,750 in costs to Dr. Syed Omar Syed Agil as per relief requested.
My name is Nurul Syahira binti Kamarudin. I will proceed with the comparison between Malaysia and United States whistleblowing legislation. Whistleblower protection laws in the United States and Malaysia share many commonalities. Disclosure of information that might constitute a crime will not be protected. For instance, WPA 2010 will not safeguard the revelation of material prohibited by the Malaysian Official Secrets Act of 1972. Aside from that, both whistleblower laws indicate that information can be disclosed orally or in writing. SOX 2002 and WPA 2010 require whistleblowers to act in a good faith. A protected disclosure cannot be excluded from an employment contract in any of the two jurisdictions. The approach used in the United States to establish whether any adverse action taken by the employer against a whistleblower is related to the protected disclosure is more flexible than the situation in Malaysia. Despite the similarities, there are many differences between the two whistleblower laws. Employees in the United States need only show that the protected disclosure was a factor in the resulting disciplinary action. In Malaysia, on the other hand, any retaliation against a whistleblower must be justified on the basis of the protected disclosure. Employees must approve that their employer's action were influenced in some way by the disclosure of a protected disclosure. although in the United States, that burden falls on employee. United States, based on SEC 1934 and the Whistleblower Protection Act 2010, WPA permit whistleblowers to be rewarded. However, there are at least 3 disagreements between the American and Malaysian viewpoint on this matter. First, under the United States position, a reward is only granted to a whistleblower in the event of successful judicial or administrative action taken against the companies involving monetary sanction exceeding USD 1 million. Secondly, the Dodd-Frank Act imposed a duty on the Securities Exchange Commission to make an award to the whistleblower. Thirdly, the payment of award is from a designated fund, that is the Security and Exchange Commission Investor Protection Fund. On the contrary, the wording of the WPA 2010 are more general when it comes to the provision of a reward to a whistleblower. In comparison to the United States legislation concerning whistleblower protection, Malaysian legislation differs significantly from the United States in a number of areas. The scope of protection on the kind of information to be disclosed is wider compared to the US position, as the disciplinary offence under the WPA 2010 include breach of Code of Conduct and Ethics. Only the WPA 2010 extends protection to persons related to or associated with the whistleblower. In addition, only the WPA expressly allows the whistleblower or anybody related with him to change their place of employment. The Whistleblower Protection Act 2010 specifically says that civil or criminal legal action cannot be conducted against a whistleblower. If the information a whistleblower provides to a law enforcement agency is fraudulent, he may be precluded from filing a defamation lawsuit. Regarding this issue, America's position keeps silent. Besides, unlike the era 1996 and US position, the WPA 2010 make it illegal to obstruct an authorized officer in the performance of his duty under the WPA 2010. In order to destroy or falsify any document or thing relevant to an investigation under the WPA 2010, and to aid or attempt to commit any of offence under the WPA 2010 in order to strengthen the investigation and detection of improper conduct. Lastly, the WPA 2010 does not provide the time limit in which a whistleblower can complain to the enforcement agency that he has suffered from detrimental action as a result of his protected disclosure.
In conclusion, the whistleblower has become an absolute necessity for every organization. This is due to the fact that such policy can contribute to the development of a secure and open environment for corporate governance. This policy also provides an appropriate and proper reporting channel for employees to act as whistleblower by discussing any improper happen in the company. The practice of blowing the whistle are important to devise strategies that effectively encourage employees to blow the whistle, as employee tips are widely as most common method of detecting fraud. In addition, providing protection to whistleblowers is an essential policy that needs to be implemented in Malaysia, the Whistleblower Protection Act 2010.